Well, thank you very much for the invitation. This is for me a very important opportunity to learn a lot of things. I must admit that to speak about criminalization of homosexual consenting relations is very strange. In year 1791, the first penal code, French Revolutionary Penal Code, ended with the criminalization of homosexual relations in France. And this was followed by the Napoleon codes, and after for several Latin American codes and European continental codes. Our Latin American tradition followed the Napoleon Code directly or indirectly. So we have near 200 years without criminalization of homosexual relations in our penal legislation. I am, a judge of the Inter-American Court, but this is a political accident. Really and essential, I am a professor, a Latin American professor of penal law. So this topic is for me very strange. We are, our Latin American societies, the million persons that live in the continent and Latin American region, we provide, we come back from different origins, different cultures, ancestries, and during these 200 years we have had a lot of problems, and we have problems. Revolutions, dictatorships, violence, civil wars, and so on. But during these 2 centuries, we have had no problem caused by the non-criminalization of homosexual relations. And also, I know also it's strange for me the discussion, because our most conservative, reactionary, traditional groups are against same-sex marriage, are against recognition of homosexuality in a legal field, but they expressly says it's not true, but it's the discourse of these conservative groups. No, we respect the person privately. They can do what they do. Only we don't want to penalize, we don't want to criminalize. No. Only we don't want the legal recognition of their existence. It's a contradictory discourse, but also this discussion is not in our countries. And this decriminalization is oldest than the disappearing of slavery in our region. Our penal codes, our independent penal codes are for the oldest are from the first half of 19th century. And slavery disappeared in Brazil in 1889, when my grandmother was 4 years old, very near in time. And the decriminalization of homosexual relations is before. We are very complicated societies, but this doesn't mean that in our societies there are no discriminations. No, we have a lot of discriminations. Discrimination in ethnic origin, nationality, illness, disabilities, and are not so fixed, so strong like in North Hemisphere. It's separated through 1 or 2 generations, and our culture is very, very dynamic. In the sense of homosexual discrimination, for example, in Argentina and in other countries of the region, we have had a very positive evolution in the last 2 or 3 or 4 decades. The change is radical in this sense. Well, the Napoleonic tradition, the French tradition, was followed by several countries of continental Europe, but there were some exceptions. One of the exceptions was Germany. Germany maintained the criminalization in his Strafgesetzbuch, in his penal code, in its famous Article 175. And under Nazist regime, it's well known that homosexuals suffered torture, persecution, were victimized with medical experiments of unusual cruelty, and were sent to the concentration camps. After Germany maintained, in post-war time, the criminalization, but only because they don't want to pay reparations to the victims of the Nazi regimes, to the homosexual victims of Nazi regimes. They must pay to the Jew victims, but if they conserve it in the law this as an offense, as a crime, then didn't pay the reparations. Only in 1969, 2 years after England, they abolished the criminalization. And exactly 22nd August 1981, the European Court of Human Rights declares that the criminalization of homosexual consent in relation between adults was against the European Convention. After this declaration in 1981, in the case Dudgeon versus United Kingdom and North Ireland, Ireland abolished the criminalization, and there are a lot of decisions of the European Court in the same sense and against discrimination, homosexual or gay discrimination. The last country in abolishing the criminalization was Cyprus, but Cyprus didn't apply the penal law since 1981, according to the decision of the European Court. Although the European Court considered that maintain the criminalization without application, but only the criminalization, the legal criminalization, was a violation to the European Convention. The East countries had the homosexual relations criminalized because, according to Stalinism, the homosexuality was a degeneration caused by capitalism, and but between 1991 and 1995, it was abolished in the countries of East Europe, Russia, Ukraine, Latvia, Lithuania. In past century, this ended in Europe. In Latin America, we have not criminalized the homosexual relations, and then we have not jurisprudence in this sense. The countries that criminalize same-sex relations are the Caribbean countries, that they are part of the American Convention, but they do not recognize the jurisdiction of the Inter-American Court. Then this case is not submitted to the Inter-American Court. But anyway, there is a case when the Inter-American Court fixed its position with discrimination, with gay discrimination. in year 2012 is the caso Atala Rifu versus Chile, where the court decided that it was a Chilean judicial decision that in a divorce they decided that the mother could not hold the children because she was living with another woman. It's similar to a case decided by the European Court in 1999 versus Portugal. In that case was the father that was living with other man, and in both cases the court, European Court against Portugal and the Inter-American Court against Chile, decided that it was discrimination, and that was against the American Convention on Human Rights. The Inter-American Court established that the right to equality and no discrimination in sense of sexual orientation and identity, gender identity, are categories protected by the American Convention under the expression other social condition established in Article 1st of the Convention. The evolution, this is the jurisdictional decision in Inter-American system, but there are other elements in American system. The other elements are came from political decisions. I'm speaking about jurisdictional through the court, but politicals are decision of the organization of the American states themselves. This in year 2008. The General Assembly that approved a resolution under the title Human Rights as Sexual Orientation and in Gender Identity. The following year, 2009, the General Assembly under the same title required to the states the adoption of some decisions to responsabilize criminalize who the persons that practices homophobia, acts of homophobia. In 2010, approved a new resolution in similar sense. In 2011, the same, and 2012. The commission, the juridical commission, the American Political Commission, presented a project on the topic. In 2013, the Assembly General approved a convention, Inter-American Convention against all forms of discrimination and no tolerance. The evolution of the jurisprudence begins with the declaration that the criminalization is a violation to human rights and goes under the criminalization of homophobia. This is a long way of the international jurisprudence. Of course, this corresponds to a social cultural dynamic of our Western legal culture, but we can say today that in our Western legal culture, the criminalization of homosexual consenting relations is something extremely strange. For me personally, as Latin American, this is so strange that belongs to the history of penal law and is little near an element of juridical archaeology. Of course, discrimination, the justification of gay discrimination like others discriminations, passed from penal law to medicine, passed from criminalization to pathologization. And as we know, medicine is also a way of social control, and a strong mode of social control. And a long history, of course, there are a long history of justifications of inferiorities, of artificial invention of illness, of diseases, of syndromes. The most absurd and long is the inferiority of women that is supported by biological, not only the medicine doctors of the Middle Age, or the inquisitors, or the medicine of the Renaissance, also with the medicine of the 19th century, or the beginning of past century, and this invention of this biological invention is justified the exclusion of half population from political life, from democratic life. When in Argentina the women could vote, I was a child. I am very old. But yes, when I was born, my mother couldn't vote. And this is a result of the discrimination of a medical invention, a biological invention. There are other absurd things, no? The Benjamin Rush, that is considered the father of American psychiatric, he thought that negritude was an illness. And he wrote this. In 1851, the American psychiatric Cartwright invented a disease called diapetomania, supposedly affected only Afro-American people, that drove them to escape from enslavement. But there are other examples of aberrant creations, invention of pathologies that are very much close to us in time. The most famous psychiatrist, a Spanish psychiatrist in times of the Franquist dictatorship, Antonio Vallejo Nájera, invented that the dissidents and oppositors to enemies of Franco regime were ill. And they invented the syndrome called Republicanic syndrome. Yes. He was professor of psychiatry. He wrote books. On the opposite, exactly in the opposite political position, during the Stalinist psychiatry considered that dissidents were ill, and they must be in psychiatric houses, because they didn't perceive that they were living in a paradise. And also religious persons. Religious was an illness. 70 years ago, the famous Kinsey report on sexuality ran the veil on medical and cultural prejudice that covered the issue in the United States, and sparked an extensive debate that finally determined that in 1974, the American Psychiatric Association finished with the medical control of homosexuals, which was reinforced by the American Psychological Association. Finally, in 1993, the World Health Organization removed homosexual orientation from its list of diseases. Okay. This is the the second part of the second chapter of the discourse of justification of discrimination. But all this jurisprudence, all this international jurisprudence and national jurisprudence, progressive jurisprudence, and so on, it's correct. It's based on the respect to the person. Human rights can be synthesized in the expression each human being is a person, and he must be considered and treated as a person. And if each human being is considered a person, we must respect him as or her as a being with moral autonomy, and then we must respect the decisions about sexuality, about its life. We must respect each existence project. Okay, these principles are not now. They come back from the Enlightenment, the 18th century. They came from the thinkers like Immanuel Kant, John Locke, and so on. And that's correct. It's the respect to the personality, the consideration of each human being as a person, as a being with moral autonomy. Okay. But in general, conducts behavior that hurts, that violates law, are not only damaging one right. This is a simplification. We must classify the violations in order to, in a way, to put a certain order, and we choose the most important damage caused by the violation. But in general, each violation of law, each illegal behavior, has a plural damage. And I think that there is another damage that is not enough considered by the jurisprudence, but international and the national jurisprudence. According to my personal opinion, it's damage with the homosexual discrimination is damage also health. Not only the health of the minority, but the mental health level of all the society. This that I'm speaking, please don't believe that this is a hierarchization of discriminations. My personal experience with discriminated persons is in this sense negative. I observe several times that among discriminated persons is a discussion about which discrimination is worse. This is very dangerous because each discrimination is the possibility of a genocide. And a discussion among persons discriminated, which is the worst discrimination, ended discussing which is the worst genocide, in one sense. In another sense, I observe that totalitarian, authoritarian systems or ideologies, in general, are discriminating in general in a lot of discriminations. It's a front of discrimination. And it's not good, the division among discriminated persons. Then I don't think that this is, that I say is hierarchy or sexual discrimination is worse. No. But it's a particularity of sexual discrimination. And we must consider this particularity. That is omitted by the jurisprudence. And the homosexual discrimination is, in some sense, different from other discriminations. Skin discriminations, religion discrimination, ethnicity, it's known from the person is a child, from the beginning. And normally it's a discrimination that is comparted by all the family or the group. Then the person is reinforced by the family, by the group, from the beginning. Is educated to fight against this discrimination. The sexual orientation is discovered in adolescence in a particular and very particular and difficult moment of psychological evolution, and when the person introjected before the hate, heard along the childhood all the hate expressions, all the discriminated expressions. He's educated in a homophobic culture. And he discovered in that particular and difficult moment of psychological evolution the hated condition. This is a fundamental difference. Each person needs positive conditions to have not a normal, because I don't know which is normality, but enough evolution, enough development of the emotional, of the affective aspect of the personality. And may a person arrive to this level of sufficient, more or less, normal, no more or less, enough development of the affective and emotional side of his personality when he is under the menace of law, under the menace of extortion, under the persecution, the policial persecution. Penal system is one of the agencies more vulnerable to corruption. Then when many opportunities of corruption is given, more corruption will be. The persecution, the hate in the family, the refuse in the family, the necessity of living in a double life. All this, in some cases, dramatic. In some dramatic cases, ending in suicide, and no so dramatic cases is obliged. This person is obliged to, in a homophobic society, to have a double life, to dissimulate. This is a neurotic condition. This is a neurosis condition, a social condition of neurosis. And a social condition is neurosis determined behavior errors. Behavior errors, continuously behavior errors. Marriage frustrated, terrible things. But this is the problem of the minority, the health problem of the minority, yes. To avoid the development of the emotional side of the personality. But it's not only the damage to health. A society is not a lot of individuals in a bottle. No. a society is interaction of individuals. Interaction. Without interaction, there is no society. And this minority interacts with all the society. The mental level, the health mental level of a society is damaged with a minority is neurotized, because this minority is interacting with all the people. Also, the conflictiveness of the society is greater. This is a problem of governance also. To govern a society with more conflicts is difficult, it's more difficult. I don't believe that there are governments that decided to create institutions, special institutions against discriminations, or also ministers against discriminations, because they are thinking that this is better for respect of the person. No! They create these institutions because discriminations creates conflicts that are unnecessary. And each society had necessary conflicts, because conflict is normal in society, you know. But there is no good to have more conflicts that are necessary. And necessary conflicts is better to avoid. This is the reason to create these institutions, the political reason. And a society with a lower level of mental health is a problem of governance, really problem of governance. This is the sense that the aspect that I observed is omitted in the arguments of this jurisprudence. It's correct, the respect of person, all this is correct. These arguments that came from enlightenment are correct. Rationalism juridical is correct. But also we have observed this aspect of this violation of human rights. And there was a jurist in Brazil in this second part of 19th century, Tobias Barreto, the chief of a old school, the Recife school. He wrote a thing that is a very intelligent thing. He said, I don't know if there is a natural law, but I am sure that there is a natural rule of law. And the natural rule of law is that law can do what it is possible to do. And law cannot do what it is not possible to do. And when law tries to do what is impossible to do, it's frustrated and has paradoxical results. And one of the things that law cannot do is to regulate feelings. Cannot regulate love and cannot regulate hate. No? They are feelings. You cannot regulate. When law tries to regulate love, he can try to regulate love to God, religion. This ending the so-called war relations that no are religious wars. I think that if a person believes in a God that orders him to kill, it's not a God. it's an idolatry. Heretic wars. When law tries to regulate love among people, among persons, it is done through familiar law. But familiar law regulates love? No, exactly no. Meanwhile, familia is going on. Familiar law doesn't work. Familiar law begins to work exactly in the moment when family is ended. Why? Because one of the two is dead, or because they ended with love and are fighting and divorce. Only in this case is when familial law begins to work. And hate also. International law is regulating war. No, it's not possible to regulate law. Yes, the Geneva Conventions, yes, but the Geneva Conventions only are trying to avoid some things, some terrible things. Don't kill the prisoners, don't destroy the hospitals, don't kill the doctors. But there's no regulating of war. Then we must be active with extreme care in trying to beg to law things that law cannot do. There is a natural rule of law, and this natural rule is indicating that we cannot surpass the boundaries of the possibilities, of the real possibilities of law. Thank you very much.